Last week's Supreme Court rulings have left millions of Americans shattered and confused as to what the future looks like, and with good reason. The decision sent a signal that these mostly white, religious, conservative, Federalist Society allies seem to be intentionally targeting the progressive strides this country made in the 20th century, with the collateral damage aimed squarely at our younger generation. Now, if you want proof, look no further than Wisconsin, Missouri, and Kentucky, which are just some of the states looking to end educational grants to minority students in the wake of the affirmative action ruling. For reference, the University of Wisconsin-Madison has roughly 50,000 students, and only 1,200 are Black. While these schools are pulling grants to minority students, Donald Trump's designated xenophobe, Stephen Miller, issued a warning letter to 200 law schools that they had better stop trying to make their schools more diverse, because that amounts to discrimination against white people. And that seems to be this court majority's bottom line. Preventing what they view as discrimination against the real victims, white conservative Christians, while authorizing discrimination against everybody else. In just this past month, the Roberts Court granted permission to discriminate against the LGBTQ community. They struck down decades of guardrails to ensure that our schools reflect our society. And they blocked the Biden administration from forgiving student loan debt, ruling that they didn't have the authority to divert funds to help financially struggling Americans, even though they let the Trump administration divert funds for the border wall to keep out brown migrants and to ban Muslims from entering the country. So the Roberts Court, to them, some discrimination is A-OK, just as long as white conservative Christians maintain a top-tier privileged position in our society. Got it. To be clear, the Supreme Court has always been the Republicans' ultimate insurance policy, and they've been working on building a court-based veto against social change for decades. Here is then Senate Majority Leader Mitch McConnell after he sealed the current conservative majority on the Supreme Court for the next half-century.
We made an important contribution to the future of this country. A lot of what we've done over the last 4 years will be undone sooner or later by the next election. They won't be able to do much about this for a long time to come.
One thing this court has made clear is that they are unafraid of ripping up decades of precedent to impose their right-wing vision on America, which should send a chill down your spine because it means nothing and no one's rights are safe. But if you are young, understand that your generation is target number one. Joining me now is Sherrilyn Ifill, former president of the NAACP Legal Defense and Education Fund and the inaugural Vernon Jordan Endowed Chair in Civil Rights at Howard University. As part of her role at Howard, she will soon launch the school's 14th Amendment Center for Law and Democracy. And I want to start, Sherrilyn, by it's wonderful to see you and congratulating you. And to be in a space named after the great and wonderful Vernon Jordan, who's such a dear, wonderful man and a great man. And you're a great woman. So I want to start with that. That was the good note. That was the good news. Let's get to the bad news. A really smart friend of mine said to me this morning that what this Supreme Court ruling in affirmative action proves is that they're not against affirmative action because they're fine with it for like the well-to-do. What they're against is us. What they don't want is people who look like you and me in elite schools.
Well, I think you hit the nail on the head, Joy, in the opening when you talked about this as a decades-long program. This is essentially all part of a program designed to essentially dismantle the infrastructure that was created after the civil rights movement to try and move us further towards equality. And, you know, these are people who have always believed that that project was worth engaging in. You know, John Roberts has had his long-term hostility to the Voting Rights Act and to affirmative action. We should never forget one of his earliest decisions was in the parents involved case, which involved a case of voluntary desegregation efforts in K-12 schools in Seattle. And in Louisville, Kentucky. And that was the case where he famously said the only way to stop discriminating based on race is to stop discriminating based on race, right? So he's got the bromides, he's got it down to math. Yeah. What is most disturbing is seeing his willingness to use and weaponize our tools. Brown versus Board of Education, the 14th Amendment in this project. Yeah. The conversation about Brown in the decision is mind-boggling, but it is part of a larger hijacking of Brown for their purposes. Last year, it was Justice Alito who used Brown for the proposition that sometimes we have to overturn cases, and this was his rationale for overturning Roe. So we see them using the very tools that were created for us for their project. And the 14th Amendment is one of them, which is why I'm starting this center, because I think there's such a lack of understanding of what the 14th Amendment means and what its intentions were.
You know, it's fascinating. The most, as I read through it, they cite Plessy a lot. A lot. Which is weird. Thomas, his first citation is Plessy. They cite Brown a lot. And in Gorsuch's concurrence, he cites Title VI of the Civil Rights Act, which has led some people to refer to this affirmative action decision as, in their minds, it's Brown v. Board for white people, basically.
I agree with you. And I think that's why so many people are concerned about the slippery slope. Like, let's be clear. This decision responds to Harvard and UNC's race-conscious admissions program. It does not talk about businesses or employment or any of the other places yet. But I think that's why people have the concern, and understandably so. I don't think it's outrageous for people to see the writing on the wall. And that's what this term on the court has been about. The jig is kind of up. We now are very clear about what the intentions are, and we're very clear that they don't intend to stop.
No.
Even the loophole, you know, there's a loophole in the majority opinion where you can tell your story, which is exactly what happens. What he's describing is in fact, the Harvard admissions program. But he says that would be okay, but not this. And this is the other thing that disturbs me, Joy. Clarence Thomas, in his concurrence in the case, says that these admissions programs discriminate against Asian American students. And that's a heavy charge. It's a serious charge with implications for how we talk about race in the country, for our connection to other communities, for political power, and so forth. But there was a trial in this case, a 2-week trial in the Harvard case. Evidence like you can't imagine, charts, graphs, studies, expert witnesses, students testifying, and so on and so forth. And a federal judge made findings in a 130-page decision that meticulous findings that the program did not, in fact, discriminate against Asian Americans, and that decision was upheld by the 11th Circuit. That's a factual decision. The Supreme Court can't reverse a factual decision, but you see them saying it nevertheless because it's so useful.
And the thing is, a lot of what they said sounded like sort of Rush Limbaugh right-wing talking points. And the outcome of it has been a couple of them. Stephen Miller, the dedicated xenophobe from the Trump administration, has now issued a warning to law schools all over the country, essentially saying, we're going to be watching you, and if you admit too many blacks, we're going to sue you again. Because they're only seemingly targeting, they don't like black and brown. They throw in Hispanics sometimes, Latinos sometimes, but they really bugs them that black people are at these schools. And then you had Senator, what's his name, from Ohio, J.D. Vance. Write a letter to several top schools, including Brown University and others, listing all of their reactions to the decision and essentially saying, how are you going to ensure that your campuses become whiter? Because if you don't, we're going to use all of the full power of the federal government to punish you.
You know, it's so fascinating. So first of all, the fact that the court has now emboldened these forces is something quite interesting. It made me even wonder about the loophole language. I wondered if maybe the Ed Blum, Stephen Miller industrial complex of, suing and carrying on about affirmative action is too good to let go. Because this is exactly what we would expect. I looked at Stephen Miller's letter. The last words of it are, "You are hereby warned." I mean, these people have delusions of grandeur, but it's enough to frighten universities and their general counsel.
Absolutely.
And so it is effective. And so what's not done by the decision, if universities are not careful, may well be done by the self-policing and the fear.
They'll be afraid.
And that's why this is an important moment, Joy, because people have to decide what they believe. Of course, they are going to comply with the Supreme Court's decision. But they should take them at their word. If there's a loophole, there's a loophole. And they should use it. And they should demonstrate their ongoing commitment to having a diverse student body.
I wonder how they would make the argument. How are they going to make the argument that we looked at your school class and there are too many blacks in it? That's going to be a hell of an argument to try to make, even in front of this Supreme Court, that we think you have too many, not enough white people, and now you guys are counting by race. Now that means you're looking by race and saying there are not enough white people and too many blacks.
That's exactly right. And I think Ketanji Brown Jackson kind of hinted at that at the oral argument in the case when she suggested that some of these arguments might create the opportunity for an equal protection claim that black students would bring about the way that race is used. But of course, J.D. Vance is not describing this as a legal matter. He is using this as a way of, well, I don't think he's even thinking about how this might play out in a court.
Yeah.
What he wants is the political favor that he
course.
gets from saying the most extreme and most outrageous thing.
It is an amazing thing that anti-blackness and really open anti-blackness has become. The Republican Party doesn't feel they have to hide it anymore. They can just do it openly.
The question, Joyce, is that a good thing or a bad thing? I mean, it's a bad thing because we're getting what we're getting.
Yeah.
But it also is true that you and I have known for most of our lives that this has already been true.
We know how they
and
feel
we have
about
been
us.
accused of race baiting. We have been accused of dog whistles. We've been accused of paranoia. And we've been gaslighted on it.
100%.
And I like an enemy I can see and fight.
Yes.
I feel emboldened for that fight. I feel like
Amen.
we have to gather our own weapons. And now, Joy, we have to pursue what we really want. We have compromised. I mean, affirmative action based on diversity was a compromise.
Yeah,
Bakke was considered a loss in the civil rights community.
Yeah.
We have been willing to compromise.
Yeah.
They're not willing to compromise. They're
That's right.
only willing to have 100% of the power and 100% of the
right.
advantage. And that can't hold.
Yeah.
So now let's begin to talk about what do we actually want in these or other institutions?
Yeah.
What are we looking for? And that's the process I'm engaged in right now, talking with people around the country about this very issue, because I feel excited about us pursuing the America that we want.
Well, we are fighting with a very strong hand because we have you, my dear sister. Sherilyn Ifill, thank you. Thank you
Joy.
very much.